What are uncommon Medicaid asset protection exemptions? Imagine finding hidden ways to protect your assets while still qualifying for Medicaid long-term care benefits. Some strategies are less obvious but can make a big difference. Let's explore these options. One of the most effective tools is a Medicaid asset protection trust. This is an irrevocable trust created at least 5 years before applying for Medicaid. It holds assets like a home or other property, and once placed in the trust, those assets are no longer counted. The key is that the trust must have a trustee who is not the grantor or their spouse, and the beneficiary must be someone other than the person creating the trust. Timing is important because Medicaid looks back 5 years to review transfers. Another option is Medicaid-compliant annuities. These are financial products purchased with a lump sum of money that turn assets into a steady stream of income. The original money used to buy the annuity is not counted as an asset anymore. However, the income payments are considered when looking at income limits. To qualify, the annuity must be irrevocable, actuarially sound, and pay out over a certain period or for the applicant's lifetime. Prepaid funeral or burial funds are also exempt if they are set up as irrevocable trusts. These are specifically for funeral expenses and are not counted as assets because they are dedicated solely to that purpose. Some seniors may have special needs trusts, which are designed to hold assets for individuals with disabilities. While more common in disability planning, they can also be useful for elder law when a disabled beneficiary is involved. These trusts do not affect Medicaid eligibility if set up correctly. Certain retirement accounts and pensions may also qualify for exemptions. For example, some IRAs or 401(k) plans are protected if the funds are not accessible or if distributions are considered income rather than assets. Rules vary by state, so it's important to check local regulations. Property that cannot be sold, like certain heirlooms or property with legal restrictions, might be exempt from counting as an asset. Also, in some states, additional equity in a primary residence is protected if a spouse or dependent lives there, beyond the usual limits. Using these less common exemptions requires careful planning and legal guidance. Timing is critical because Medicaid's 5-year look-back period penalizes transfers made within that window. Proper use of these strategies can help preserve family wealth and still qualify for Medicaid. Consulting an elder law attorney is essential to avoid penalties or ineligibility. In practical terms, setting up a Medicaid asset protection trust years before care is needed, purchasing Medicaid-compliant annuities, and establishing irrevocable funeral trusts are smart moves. These options add extra layers of protection and can help keep assets in the family while meeting Medicaid requirements.